Late last night, Donald Trump's Department of Justice made a stunning and incriminating admission to two federal judges in the Southern District of New York. In a letter sent to Judges Richard Berman and Annalisa Torres, overseeing the Epstein and Ghislaine Maxwell matters, the DOJ quietly conceded that it has failed to comply with the Epstein Transparency Act, a federal law requiring the public release of Epstein-related records by December 19th. Until now, the DOJ had claimed it was working diligently and coordinating closely with survivors. But those claims directly contradict sworn declarations filed by survivors themselves, who say they've been kept in the dark, ignored, and mistreated by Trump's DOJ. The letter exposes what many suspected all along. The department has not complied with the law and is now trying to explain away that failure. Under the Epstein Transparency Act, the DOJ was required to release all responsive documents by December 19th, followed within 15 days by a report to Congress detailing every redaction and justifying them under the narrow categories allowed by the statute. We are now at the end of January, nearly February, and none of that has happened. In its letter, the DOJ begins, as bureaucrats often do, with the word respectfully, before effectively confessing to violating federal law. The department admits the materials are required to be published under H.R. 4405, the Epstein Transparency Act, but conveniently omits any mention of the statutory deadline. It's the legal equivalent of saying, yes, the speed limit is 65. I was going 105, but let's focus on how carefully I'm driving now. The DOJ claims it is still identifying documents, reviewing them, applying redactions, conducting quality control, and preparing for publication. But here's the problem. The Act does not allow redactions based on privilege. The law is crystal clear. Redactions are limited to protecting survivor identities, depictions of abuse, and highly sensitive personal information such as social security numbers. There is no allowance for deliberative process privilege, executive privilege, or attorney-client privilege. Yet the DOJ quietly slips the word privileged into its explanation, hoping no one notices. That single word changes everything. If the DOJ can unilaterally decide what is privileged and no court can enforce compliance, then the DOJ becomes the sole judge of its own misconduct. That is not how the rule of law works. The department goes on to boast about reviewing millions of pages of emails, texts, videos, and recordings, while claiming it is protecting victims. Even though earlier productions leaked victim information and sensitive personal data, it then descends into bureaucratic word salad about document management systems and internal processes that explain nothing and justify even less. Perhaps most damning is the timeline. The DOJ now says attorneys and agents are conducting page-by-page reviews and electronic searches. But what exactly were they doing last February, when then Attorney General Pam Bondi claimed the documents were already on her desk? What about March, April, May? When the DOJ said 1,000 FBI agents were working on this, were taxpayers funding a year-long performance? Even now, the DOJ refuses to provide a completion date. No rolling production, no deadlines, just vague promises of compliance in the near term. A phrase that could mean weeks, months, or years. This letter is not evidence of compliance. It is a roadmap of non-compliance. Imagine violating a law, then submitting a formal document calmly explaining how and why you're continuing to violate it. Legal analyst Harry Littman put it plainly. When the DOJ says it is complying, what it actually means is that it is describing its failure to comply. The statute was unambiguous. Congress set the deadline. Trump signed the law, and the DOJ ignored it. Worse still, it has failed to explain or justify a single redaction, as the Act explicitly requires. The deeper problem is enforcement. There is no adversarial party here. The DOJ and the defendants share the same interest: non-disclosure. Victims cannot compel compliance. Congress lacks enforcement power. And without a judge empowered to evaluate privilege claims, the DOJ can stall indefinitely, using delay itself as a strategy. The irony is brutal. Survivors are told to report problems after publication, even though the DOJ's own failures have already re-traumatized them. The department that should be fighting for transparency is instead shielding powerful interests and running out the clock. At this point, we are firmly in adverse inference territory. The longer this delay continues, the clearer it becomes that concealment, not compliance, is the goal. This letter doesn't show progress. It documents a cover-up. And unless future leadership chooses accountability over healing rhetoric, this failure will stand as one of the most shameful abdications.